PD Law Center. Also on my right side, I have Monica Guisa Rosina. She's a public policy manager at Facebook Brazil. She holds a PhD in international law, and she's also a professor of law at Fundação Getúlio Vargas in São Paulo. On my left, I have Neide Oliveira. She's a federal prosecutor in Rio de Janeiro, Brazil. She coordinates a task force on cybercrime at the Office of Federal Circuit Prosecutors in Rio de Janeiro, and a project called Digital Education in Schools, under the auspices of the same branch at the Federal Prosecutor Services in Brazil. I have Peter Meisek, Peter Meisek. Sorry. He's graduated from Vienna University, focused on shortcomings in democracy theory and analyzing Egypt with a master in 2012. And after studying international relations at Warwick University for 1 year, and since June 2014, and he also teaches at course at Columbia University in Internet Policy and Governance. And then I have Stephanie Felsberg. She has been working as a senior researcher at A2 Key for Development, focused on censorship. And just on my right, I have Susan Schaumann. She's an Internet Policy Specialist at the Office of International Affairs at the NTIA. In her work, she focuses on Internet-related intellectual property, trade, and intermediary liability issues, tracks the working group on enhanced cooperation, and engages in the Internet Governance Forum. To introduce the first round, I would like to give you a brief introduction on some food for truths, and afterwards invite our distinguished speakers to build on that. First of all, an internet shutdown is an intentional disruption of internet or electronic communications, rendering them inaccessible or effectively unusable for a specific population or within a location, often to exert control over the flow of information. Internet shutdowns are an intervention on the infrastructure level and have been increasing in frequency between 2016 and 2017. Causes for these disruptions vary and include network outage and government mandatory blockades, usually motivated by national security or public safety concerns, but also political instability and to stop protesters and control elections. Depending on the cause of the disruption, it may prevent the vast majority of people in a region from accessing a product, like YouTube in China, as of March 2009, or restrict access for certain segments of the population, like all Google products in Kenya in February 2012. The economic impact alone was estimated in £1.9 billion, but the huge impact on human rights and freedom of speech cannot be estimated or accepted. An application or website blocking are distinct from internet shutdown. Website blocking is usually used by governments to prevent access to illegal content such as online gambling, intellectual property, child sexual abuse material, and national security. However, apart from issues related to child safety, there is a little international consensus on what constitutes appropriate content from a public policy perspective. Even in the case of child online protection, there is a better approach instead of blocking. Rapidly remove the content at the origin, at the hosting content provider, and assist law enforcement with the metadata needed for prosecution of the offenders. and support a national hotline as an online resource that offers the public a way to report legal content in each country, in accordance with local legislation. The multi-stakeholder international community, convened in Net Mundial Conference in São Paulo in 2014, reached consensus on a set of principles that should be considered as a baseline for our discussion today. Rights that people have offline must also be protected online. And those rights include, but are not limited to, freedom of expression and association, privacy, accessibility, freedom of information and access to information, development, and diversity. People have the right to keep the Internet as a unified and unfragmented space that should continue to be a globally coherent, interconnected, stable, unfragmented, scalable, and accessible network of networks, based on a common set of unique identifiers, and that allows data packets, information to flow freely, end-to-end, regardless of the lawful content. I also would like to recall the Manila Principles as an example of best practice guidelines for limiting intermediary liability for content to promote freedom of expression and innovation. And at the national level, the Brazilian Internet Steering Committee has approved by consensus in 2009 a set of 10 principles for governance and use of Internet in Brazil. Those principles inspired the discussions and shaped the Marco Civil, our Internet civil rights framework. 4 of them are directly related to our session today, and I would like to highlight them as an additional suggestion for our discussion. Freedom, privacy, and human rights. The use of Internet must be driven by the principles of freedom of expression, individual privacy, and respect for human rights, recognizing them as essential to preservation of a fair and democratic society. Number 2, neutrality of the network. Filtering or trafficking privileges must meet ethical and technical criteria only, excluding any political, commercial, religious, or cultural factors, or any other forms of discrimination or preferential treatment. Number 3, non-liability of the network. All action taken against illicit activity on the network must be aimed to those directly responsible for such activities, and not at the means of access and transport, always upholding the fundamental principles of freedom, privacy, and the respect for human rights. And number 4, functionality, security, and stability. The stability, security, and overall functionality of the network must be actively preserved through the adoption of technical measures that are consistent with international standards and encourage the adoption of best practice. Having said that, I would like to invite our distinguished colleagues to address the first policy question proposed to this session. With your experience in different countries, regions, and contexts, what are the overall impacts of international shutdowns and application blocking in local and global terms? Based on your experience, which would be some local specialities important for this debate? Perhaps we should start with Monica.
Thank you. Thank you so much for having me on this panel. It is an honor to represent Facebook Brazil, and a pleasure to be among so many familiar faces. Thank you, Thiago. There have been several panels at IGF this year on internet disruptions. And if there is one consistent message across them, is that internet disruptions isolate people and communities. And because the internet is one of the most powerful engines for economic growth, disruptions also affect the economy. Facebook's mission is to give people the power to build community, that's our new mission, and bring the world closer together. Over 2 billion people around the world are using Facebook on a regular basis across the globe, and that includes the 122 million monthly active users in Brazil alone. At Facebook, we strongly oppose shutdowns and any other disruptions of the internet as a whole or of a subset of websites, apps, and or services. Blocking specific apps and services risks fragmenting the free, open, and global internet, and we're deeply concerned by the trend towards this approach in some countries around the globe. Disrupting access to the internet or to apps and services like Facebook and WhatsApp separates people from their family and friends, chills free expression, harms stability because it interrupts normal economic and social activity, and it undermines economic activity and growth because it harms small and medium enterprises and it disrupts the startup ecosystem. Even temporary disruptions of internet services have tremendous negative economic and social consequences. On a final note, because I know this is a larger panel than it was intended originally, and I'll just stick to my 2 minutes, I would just like to highlight, Thiago mentioned a few numbers on the economic impacts of shutdowns and blockings, but I would just like to highlight that several studies have recently looked at this issue and did, according to strict methodologies, did the maths of the costs and negative economic impacts of internet disruptions. And one of them is a study conducted by the Brookings Institution, and it estimated that internet disruptions cost countries at least $2.4 billion in 1 year alone. And the estimated date was between July 2015 and June 2016. In this study, Brookings identified 81 disruptions across 19 countries. And in Brazil alone, the estimated costs of the WhatsApp blockings were as high as $320 million. In addition to the Brookings Institute study, Deloitte has also been looking at the costs of internet disruptions. And a 2016 Deloitte study released via the Global Network Initiative found that internet disruptions cost countries as much as $23 million per 10 million people per day in an illustrative high connectivity country. If you move to less connectivity countries, that would fall to 6.6 million per 10 million people per day. So in sum, we do not believe that the blocking of an entire platform is a proportionate response when seeking the enforcement of legal orders. Blocking has the effect of imposing a collective punishment on all of the users of that platform and is not directly relevant to the harm that authorities are seeking to address. Thank you.
Thank you very much, Monica. And then I immediately turn over to another Brazilian, Neide Oliveira from the Federal Prosecutor Office.
Thank you, Thiago. Good afternoon. I will speak as prosecutor, as federal prosecutor. The rights to communication and freedom of expression, like all other rights guaranteed in the Constitution of the Brazilian Republic, are not absolute and can be modulated for the protection of other equally important rights and that are protected in investigations of serious crimes such as the right to life and the right to public security. The WhatsApp application, for instance, the most used app in Brazil, which has been affected by judicial decisions suspending its service in Brazil, brought invaluable contributions to the discussion regarding the fundamental rights of freedom and communication. No doubt, the app is very valuable when applied to lawful activities. But no one can argue censorship when legal measures are taken to prevent and deter messages used for illegal purposes, such as pedophile activity, for example. In Brazil, the 6 decisions that resulted in the suspension of WhatsApp due to non-delivery of encrypted content occurred due to the company's lack of explanation to the judges. After the proper explanations were provided for, the decisions were reversed in an appeal. These clarifications about the technical impossibility of complying with the legal determinations were given by the Internet service provider after the total disrespect of the Brazilian law by the application. In many cases, even the metadata, which is not encrypted in any other application, was not delivered, making it impossible to start the investigation of serious crimes, such as the planned murder of public agents and other actions of criminal organizations. The measure is not disproportional either, as it aims precisely to protect the other rights. The proportionality must be measured in concrete terms on case-by-case basis. In Brazil, there was an exception period, and due to the lack of clarifications by the application itself about its operation. However, after the Federal Prosecution Service gathered all the branches of the Brazilian Prosecution Service and published in August 2016 a technical note distributed to all members of the Prosecution Service in the country, clarifying that this was not the best measure, there has been no request for suspension of application and consequently no legal decisions underneath. The freedom of expression cannot be an excuse for the practice of crime, as stated by our Supreme Court. The freedom of expression and communication is limited by the Constitution, along with other rights that must be respected, such as the right against child abuse, privacy, intimacy, and security, only to name a few. The violation of the social right of security is the violation of the principle of the dignity of the human person, who is one of the foundations of the Federative Republic of Brazil in accordance with Article 1, Section 3 of the Constitution. Without social security, other fundamental rights would be in danger. The right to freedom of expression and communication does not prevail, inexorable in face of other constitutional rights, among them the right to freedom, to life, child protection, among others. The Federal Prosecution Service does not deny that freedom of thought and of expression is a fundamental right. On the contrary, it seeks to enforce the Article 13 of the American Convention on Human Rights, which recognizes the need to protect public safety and order. If, on the one hand, the rights of freedom of expression and to communication are essential, they can and should be restricted when other rights need to be protected. Precisely for this reason, in the Internet Civil Frameworks in Brazil, ensures the privacy of data, protecting it from being accessed by authorities without a court order. The legislation also establishes punishments for those who grant unauthorized access. In at least 2 situations in 2017, WhatsApp application was down, without major incidents to society or the deprivation of the right to communication and freedom of expression. People continue to exchange information, news continue to be published, and business continued being performed normally, with or without the application, without major drawbacks. In this context, we have the following situation. WhatsApp is indisputably a highly useful service, but it systematically violates Brazilian law. Its suspension, even when determined by its own failure, despite its claim, does not affect the exercise of any rights, but the stubborn failure to comply with legal decisions puts at risk the lives, health, public equality, the safety of children and adolescents, and the exercise of other rights. Despite this, the company insists that it cannot be punished for these violations. Therefore, the law itself and Articles 2 and 3, which had been inspired by the principles of Internet governance, published by the Managing Committee of Internet in Brazil, imposes the respect for human rights, for the user, citizenship, as well as plurality and diversity. The devices of the Internet civil framework form a coherent system which ensures the protection and also the means of appropriate sanctions in case of violation. The sanctions envisaged abstractly in the norm, understood within this framework, are neither disproportionate nor unconstitutional. As explained above, they are addressed to Internet service providers who, while ensuring certain rights, cannot, in their activity, violation others equally important and protected by the Constitution. The system of guarantees and penalties provided for in the Brazilian civil rights framework is not unconstitutional on its face because it must be interpreted as a balancing test. The framework preserves rights and ensures legal means for compliance with its rules.
Thank you very much, Lady, for your statement. We are very strict on time, and then I immediately invite Professor Carlos Afonso, who represents the Internet Society Technology Institute of Rio de Janeiro, which is one of the co-organizers of this session. Please, Professor.
So, thanks, Thiago. Good afternoon, everyone. It's a pleasure for ITS to organize this workshop together with CGIBR, and I really have to say, like, it's all the heavy lifting of bringing everyone together is it's all due to CGIBR. So thanks for the invitation. So quick points here in the discussion on blocking, on internet shutdowns, but I'll focus mostly on application blocking. So one thing it's important for us to understand that sometimes when we have application blocking, it's due to the behavior, the acting of a third party, of a user, such to say, in the platform. And to tackle and to fight against illicit activities that are done in the platform, it's important for us to differentiate between the illicit that is done by the person in the platform and the illegal status of the platform on itself, because sometimes we end up mixing the two things. It's important to understand that one thing is the user conduct in the platform. The other thing is to portray the platform as a whole as being illegal, illicit, and that will lead to blocking. I will mention 3 quick documents that mention the issue of blocking. This is just to say that the discussion on app blocking or website blocking is definitely not new. If we go back to 2011, during the discussion around SOPA and PIPA in the US, there was a whole discussion about blocking done through DNS. And this is just one document for you to take a look on if you are interested in this discussion. There was this document called Security and Other Technical Concerns Raised by DNS Filtering Requirements in the Protect IP Bill. It's a document that is authored by Steve Crocker, Dave Dagon, Dan Kaminsky, and other researchers. And they are very explicit against using DNS to block websites, saying like DNS filters would not be evaded easily and would likely prove ineffective at reducing online infringements. Further, widespread circumvention would threaten the security and stability of the global DNS. So this is one example from 2011, the discussion around SOPA and PIPA. If we bring the discussion more recently to 2015, you have this very interesting document from the Swiss Institute of Comparative Law saying that, and I'm doing like a quick translation here, after the decision for the European Court of Justice in 2014 that allow the blocking of websites, there has been a lot of objections to this development at the European Court. If you look especially on German law courts deciding against this type of decision, claiming threats to human rights, proportionality, and some doubts on the transfer of judicial power to third parties. And in 2010, this is the third document that I mentioned, the UK Ofcom released a document called Site Blocking to Reduce Online Copyright Infringements. And they play around with different types of blocking that could be made, and they end up saying that DNS blocking would perhaps offer a simpler and less expensive option, but it's likely to be fully effective only until DNSSEC is implemented, so perhaps it's not a long-term solution. IP address blocking is simply not granular enough, and the easy by which it can be circumvented would suggest that it's not a suitable technique candidate. So this is just to say that debate goes on from a long time. And if we look at the Brazilian perspective, it's important for us to make sure that this discussion right now in Brazil, it's being brought to our Supreme Court, because the Brazilian Internet Bill of Rights that has been mentioned a lot here, in one of its articles, it has this one provision that says that it's possible for application provider to be sanctioned by the suspension, but it's not the suspension of the whole application provider, but only of the activities that are mentioned in Article 11. And Article 11 of the Brazilian Internet Bill of Rights deals with the collection of data. So when you hear about this situation saying the Brazilian Internet Bill of Rights allows for blocking of websites, our personal opinion is that that's not the case. It allows only to the suspension of the collection of data. That will be the interpretation of Article 12. But this issue is under dispute right now at the Brazilian Supreme Court. We expect a decision on that by next year. So this is a subject that is now in our Supreme Court. I would just finish saying that, of course, we had our situations of WhatsApp blocking in Brazil, the 4 times that this suspension ended up trying to be achieved. And maybe one simple fact that show how complicated this discussion is that one of the WhatsApp blockings that we have in Brazil end up taking WhatsApp out from some parts of Argentina and Chile as well. You can say that, oh, that was a mistake that was done when the blocking was implemented, but mistake or not, I think it's important to understand how we are dealing with the infrastructure of the internet, and once we do this, we open up for situations like this one to happen, and that's super complicated, and those are the topics that I would like to raise here in the beginning. So I'll stop here. Thanks, Thiago.
Thank you very much, Professor Carlos Afonso. Now we have a frame of the Brazilian situation, and we'd like to invite Susan Schaumann to give you a more international perspective on that issue.
Thank you kindly, Thiago, and good afternoon, everyone. It is a real pleasure to be here with you at the 12th IGF. So today I'd like to share some insights from a session at this year's IGF USA that NTIA helped to co-organize. The session was titled Healing Internet Fragmentation. And for the purposes of the panel during this session, our speakers stipulated to a 3-part classification of fragmentation, that is technical fragmentation, commercial fragmentation, and governmental fragmentation. So we had an excellent mix of speakers, one of whom shared his technical perspective. And his remarks focused on, and this is very relevant to what Carlos and Ms. Oliveira were just speaking to, his remark is focused on the impact of high-level policy decisions on the Internet's infrastructure. For example, when governments will restrict the free flow of data across borders or forcing localization of data, what may make sense from a geopolitical point of view to some, making sure that data stays in a country, for example, from a technical point of view, often has big consequences. And so these decisions can actually jeopardize the Internet's ability to self-heal and to contribute to a loss of the natural resilience that exists in the physical and transport layers underneath. So network operators really face a tough challenge, and because in practice, the implementation of these policies, they take place further down the stack at the packet forwarding level. And that is really where simplicity is a key design principle. So what is the solution here? What we discussed during that panel was that we need to build capacity and understanding between the political level or the judicial level and the technical level. We need to develop translators, so to speak, to be able to convey very simply and very practically the very real consequences of some of these decisions that are made. So as we heard from our colleague from the Federal Prosecution Service, it was the technical explanations that, that assisted in finding the best measure to effectively address the very real needs of law enforcement, but also ensure that the application of any such measures, technical measures, are not overbroad and disproportionately impinge upon the human rights of users. And also, as Carlos mentioned, the DNSSEC paper that came out during the SOPA and PIPA discussion really illustrated the practical impact of the legal solutions that were proposed. So as we go from policy, and as that policy is expressed through legislation, all of these need to be able to contemplate the technical impacts, and which ultimately can have human rights implications. Thank you.
Thank you very much, Susan. Moving from the US to the Asia-Pacific region, I would like to invite Professor Parker to...
I didn't know that this session is going to start out with a showdown between Facebook and prosecutor's office, but I think I'll mention a little bit about Brazilian situation and then give Asian Pacific perspective. So I think what happened with the WhatsApp in Brazil, it's not just a free speech issue, but it's a privacy issue. It raises a very important doctrinal issue of whether the court can punish someone served with warrant for not carrying out production of certain confidential data. There have been discussion about what a warrant is, whether warrant is a permission for the prosecutor to access the information, or whether it is an affirmative order for private party to do something, like production of confidential information. The mainstream theory is that warrant should not be an affirmative order. So, for instance, in the United States, the court order could not force Apple to write a new software that allows decrypting iPhone of a known terrorist. That status was made possible because of the prevailing interpretation that a warrant is only a permission to the prosecutor. not an affirmative order on private parties. So coming back to Brazil, by shutting down the whole app for failure to produce information, the court was attempting to enforce an affirmative order on Facebook, which cut against the prevailing interpretation of the legal nature of a warrant. And I'll use my last minute on the Asian Pacific. More on Korea, and then I'll talk about other parts. Korea has an administrative censorship body, Korea Communication Standards Commission, which does comprehensive censorship of the internet, some of which have affected shut down the entire website. For instance, northkoreatech.org, which is an information website run by a British journalist on I must be saying something right. So, thank you for the fanfare. On the information on the information technology used by North Koreans. Korea has a national security law that punishes any speech condoning or praising North Korean government position, and using that law, the police requested shutting down of that website, and it's usually done through DNS blocking, and the whole website was shut down, although the website only neutrally presented information about how much North Koreans use the internet, how much mobile phone they use. We filed a administrative lawsuit against that decision. We canceled it. The cancellation was affirmed just a month ago. So this was, I think, in surveying the world, this was the second time, probably after a Turkish activist undid the blocking order on YouTube 3-4 years ago, was the first time that a foreign people's right to access the foreign website was recognized and given effect by judiciary.
Thank you very much, Professor Parker. The time is very restricted, and I would like to come back to Europe and give the floor to Stephanie, please. If you could speak in 3 minutes, I will really appreciate that.
Hi, everyone. Also, I want to say thank you, and I'm very happy to be here. I will talk a bit more about politics and not so much about laws, because my background is in politics and not in legal studies. And I'll speak about Egypt. So I'll talk about two major instances of internet shutdowns and blocking. One is in 2011, that happened during the Egyptian Revolution, and the second instance of blocking started in May 24th this year and is well underway as we speak at the moment. So I'll analyze and compare the impacts of both, and then also see how they contribute to the general debate. I'll try to be short, so if you have any follow-up questions, just come up to me afterwards, and I'll tell you the details. So in 2011, in the middle of the protests against the regime and President Mubarak, the internet was shut down for 5 days on the night of the 27th to the 29th, 27th to the 28th. On the 25th, Twitter was blocked, the 26th, Facebook was blocked, SMS was shut down, and on the 27th, the internet was blocked up completely. We've done some research at our center on how exactly this has happened, and there's different theories because access to this type of information has also been difficult to come by. And in 2017, now what's happening is that there's a very large number of websites that has been blocked as of today, and the number is 465 websites. which is a staggering amount of websites that are being blocked. There are international news medias, local news medias, Al Jazeera, HuffPost, Arabic. Most critical voices within Egypt, all their websites have been shut down. ISPs, things like the Wayback Machine, voice over IP services like Skype have been blocked. And this is an unprecedented move from the side of the government, because before, what happened is a little bit in line with the principles that were discussed before, but applied very wrongly, because before, what happened was that they wouldn't prosecute or put responsibility on the platforms or the news media themselves, but on individuals, where individual journalists or activists would be arrested. And now there's been a shift where entire platforms and news medias and websites are being completely blocked. When we look at the implications of basically this type of censorship that happened, is that it's interesting to see that somehow the intended effects might have been a little bit different, because in 2011, the block didn't necessarily stop the wave of protests that was happening and that was unfolding, but on the opposite, people had to go down on the street and find out what was happening. So in the end, the opposite of what was intended happened. And then I want to follow up a bit on what Mr. Sina said about the economic cost of the shutdown, because there was a quite large economic loss that happened in Egypt because the internet was shut down for 5 days. And there's different numbers that are out there. There's estimates of an economic loss of around 18 million US dollars, totaling a minimum of $90 million during the 5 days of the outage. Other estimates are at around 110 million overall. And so, yeah, I think this is one point that I think might be an interesting aspect to add to the current debate, to move maybe be not to just on aside from the focus on rights and the legal aspect of things, to also look at the economic cost, because from our perspective, that might also be a way to argue and to show that the impact is not just freedom of speech, because some governments don't seem to be as receptive to those rights-based arguments, but economic arguments, in our experience, carry a different weight, sadly. And a quick note on the 2017 website blockings. The economic cost is not the same as in 2011, obviously, because only individual websites are affected. But the effect is basically an information blackout, because all independent websites are blocked, and the existing and remaining media are very much aligned with the official story of what is happening. And it's very interesting to see that this is happening now, because in Egypt, people have been used to a plurality of media that was available throughout the 2000s, because there were liberal economic policies and the internet was a rather open space. But there's a shift that happened. It's also interesting to note that people are aware of the censorship and of this blocking that is going on. And I think this is also something that's important to note when we think about internet censorship and blocking, that this type of blocking is very different from, let's say, copyright takedown notices that are not as obvious. So that something that is as blatant as this is at least easier to counter. Thank you.
Thank you very much, Stefan. And now, I would like to give the floor to Peter from Access Now, please.
Thanks. Thank you. I'll try to keep this brief. I'm Peter Maisak, General Counsel from Access Now, and I teach a class at Columbia University. At Access Now, we've tracked the trend of internet shutdowns across the world. We have a shutdown tracker that has found the instances rising. According to our definitions and our coalition called #KeepItOn, that's a coalition of more than 150 organizations internationally. According to our research, shutdowns have increased from 56 instances in 2016 to more than 77 this year. And we do count Brazil's blocking of WhatsApp in our definition. I do want to take it back to those principles of internet governance. I think that we started the session with. I think it's clear that the multi-stakeholder processes and the idea that all those affected by a decision ought to have a voice in making that decision are key to building the internet as we know it and the horizontal organizations that we currently depend on to organize it. And these decisions to shut down the internet are clearly unilateral decisions that do not consult with the affected stakeholders and are not made through transparent or democratic and inclusive processes. We actually know very little about how the decisions are made, who makes them. We see the impacts and we can guess at attribution, but it's been rare that courts or legislatures have honestly and openly, robustly debated who should have the power to deny us access to the internet, when and under what circumstances. These shutdowns are likewise a form of discrimination. They violate principles of neutrality. They're in fact targeted at specific applications, services, and communities. As far as stability, we heard a little bit about how internet shutdowns and other types of blocking can damage the infrastructure itself, can leave lasting damage, in addition to the acute harm to networks. I would add that if we're talking about stability on the internet as a principle of internet governance, we should ask what's the purpose? Stability for peace and stability's sake? No, I think it's for dependence on an internet, on a network that can build trust and ultimately growth. And all of these values are offended when the internet is shut off at will. And then finally, to human rights, I think we've heard a bit about the impacts on freedom of expression, as well as on the economy and economic, social, and cultural rights. I would add that we have recorded at Access Now shutdowns that directly impacted the right to life. We have 2 instances where women were unable to contact their doctors and lost their unborn children during complications with their pregnancies. So these are instances that we've recorded. We have to assume there are more that we know of, and have to assume that other people were unable to access emergency medical services because the networks they depend on were suddenly and momentarily deprived. So I'm very hopeful, even though we've seen some trouble with the courts approaching this issue, that more judges will see a more robust determination of what's proportional when it comes to blocking the internet. I think the proportionality test is true, but I think the factors, the ways that the internet impacts our daily lives are not well understood. They're not economically quantified in such a way that judges can make these determinations readily. And as I said, there are knock-on effects of shutting down services. And I would call on, just as the United Nations in the Safety of Journalists resolution at the General Assembly this month has done, I would call on more organizations to condemn disruptions unequivocally as violations of human rights in the digital age. For telecom companies to continue pushing back and being more transparent about these orders they receive, and for more civil society and more support for the Keep It On network calling out this problem. Thank you.
Thank you very much, Peter. So this brings us to the second part of this discussion. And I think those were very interesting comments by our panelists to show the plethora of issues that we're addressing here. And I would say that all the different issues that you heard here are can be perceived as symptoms of a broader illness. And the illness is a challenge that all stakeholders, governments, companies, civil society, everybody faces alike, is how national laws are applied on the cross-border internet. I don't need to explain anybody in the room that most online interactions today involve multiple jurisdictions at once. And this brings a lot of new challenges. And the questions, especially if we talk about shutdowns, is at what level with what tools and through what procedures are national laws applied on the cross-border internet. And I want to take the opportunity now, as I briefly have the microphone, to provide a few elements of clarification, because I think shutdowns, they are a fairly new phenomenon, and it is very important that we all use the same vernacular and don't confuse certain terms and are very precise when we talk about shutdowns or other measures of how national laws are enforced on the internet. When we talk about shutdowns, I believe we talk about, as was said also, about infrastructure shutdowns. They can be just the mobile internet, they can be the entire internet, they can be fully national, or they can be in regions. This is certainly the most extreme way for a government to control the internet, which is by shutting it down so that it's not accessible anymore. And obviously, as the panelists mentioned, this has severe consequences for human rights and the economy. However, shutdowns also can have cross-border effects, adverse cross-border effects, unintended cross-border effects, and I want to highlight the case of Egypt. Here it was interesting to see that while the internet was shut down, the cross-border transit traffic was not touched. But you can also have instances in theory where the internet is shut down and services that are located in that country or have data centers at that countries become inaccessible for users worldwide. And the other issue that was mentioned, and this is the case, for instance, for the WhatsApp case in Brazil, this is the ordering of ISPs to block certain websites or applications. Here again, websites and applications, this is not the same thing. This can be done through DNS blocking or IP blocking, so the technical modalities vary. And also the reason why things are blocked vary, and I think it's also important to keep this in mind. The case of WhatsApp in Brazil, this is an issue of cross-border access to user data. The reason why WhatsApp was made inaccessible in the Brazilian jurisdiction was because WhatsApp did not comply with an order to produce data that was requested by Brazil. You can have other instances where the issue is cross-border content removal, or issues or instances where courts or other public authorities try to make content unavailable in a given country. So I think it's very important to keep this in mind when we discuss those issues. And there's even a third area that no one touched upon here, but that is part of the larger picture, which is domain suspensions through registrars or registries. This is a very technical thing, but this is also another way of how applying national laws that can have severe cross-border effects. I think the challenge that we collectively in this room today can advance on is how to build a better common understanding of the challenges that we collectively face with regards to shutdowns. What is the way forward? We want to look at the next 10 years. This is a new phenomenon, and so I think this a good starting point to grasp with this phenomenon is to see, are there emerging principles, procedures or standards with regards to internet shutdowns. And I would maybe like to give the opportunity to the people here in the room, which were all very knowledgeable on this topic, to open the floor and to ask you, looking at the different instances of internet shutdowns, do you see emerging patterns in terms of principles, procedures, and standards? What is your view on this? Maybe we can collect 2-3 comments from the floor in that regard. Who would like to go first? Yes.
I'm Juliana, I'm from Brazil, and I have a question for Neide. I understand the need for public security and respect to jurisdiction and sovereignty, but I'd like to know what are the criteria that you use to evaluate the limits between what concerns public security and what is surveillance, and who establishes those criteria?
Neide, would you like to answer directly?
Sorry, Juliana, if you don't mind. I'm sorry. Sorry, Juliana, if you don't mind. I'm a colleague of Neide. My name is Priscilla. I'm a federal prosecutor also. And tomorrow, thanks a lot for the explanation, Paul, because I wanted to put out here some things about the penalties. First of all, what we need to understand is that the block I would like to say block instead of shutdown, and suspension of some services are penalties. And when we have a penalty, it's because some company disobeyed some orders in Brazil. We work with very severe crimes. We are talking about crimes, investigation, and procedures in criminalities, I'm sorry. So we are talking about child pornography, we are talking about rapists that comes the images in the internet. And when we talk about these penalties, it's not just very well mentioned by Carlos, it's not just in the internet civil frame work in Brazil. We have also our civil code, our procedure civil code that gives the power for the judge under circumstances that under the law to give these penalties. Another thing, if I can just complete very quick, Thiago and Paul, it's because we from the from the Federal Prosecution Office, we enforce it that these penalties just can be used or just have to be used by the judge with a lot of precaution and in the last resort. Why? Because when you do this, when you have a penalty, you want to penalize not the users, not the consumers. You want to penalize a company that's not contributing with the investigation. And just really to finish, we are talking about, and as very well said by Monica, about the economic impact. I just want you to think a little bit, as we see in our daily work, how much you would pay, a mother would pay, to have some information that could give her a succeed investigation to take out his son or his daughter from a rape that's going on the internet. We just can't start an investigation like this with some metadata, with some things, and then we try to get it. When we don't get it, we try to solve with financial penalties, not blocks. We don't want to block anything. It comes as a response, and it comes in the last resource. Thank you.
There was another question there.
Yeah, my name is Luan. I'm from Brazil. I'm a CGI BR fellow. My question is to Monica. You are here as a Facebook representative, but when law enforcement agencies go to Facebook offices to talk about WhatsApp, you say that you're not related. So how this company separation works? Because you're here a public policy, you can speak on behalf of WhatsApp, but when it's a law enforcement formal request, you can't. How does it work?
Please go ahead.
Thank you. That is a great question. I'm not here as a representative of WhatsApp. I am a public policy manager for Facebook Brazil, and of course WhatsApp is part of the Facebook group of companies. So whenever there are requests from law enforcement, those requests are directed to the WhatsApp office in California, and the WhatsApp team, to my knowledge, responds to those requests.
Thank you very much. There's another question over there, please.
So I had some comments on the trends that I'm seeing in India with respect to shutdowns, because we've just, the last 3 days, there was a shutdown in a city called Udaipur. We've had about 72 shutdowns this year alone, which is more than double of what were there last year. The other thing is that we've had in one particular state, in a small state, there were 100 days of shutdowns, a continuous 100 days. And we've had instances in the state of Kashmir where across a period of 6 months, there have been repeated shutdowns. What this does to people is that it makes them lose faith in having internet access. And we've heard that directly from people who faced shutdowns in Kashmir, as well as from Darjeeling, where the shutdown has happened. Impact that it has on people is that, for example, students who are going to another state to study, all admission forms are online. They're not able to file for their admission. Both these states that I mentioned are tourism-heavy states, and travel operators and tourism companies have lost money because they couldn't take bookings. Journalists who were reporting on the situation on the ground have had to file stories using SMS because no internet. There were people businesses weren't able to file their taxes because all tax filing is online. there is a disproportionate impact that it has on people's lives. What we're seeing, which is even more worrying over the last year especially, is that there are now preemptive shutdowns, where there's an assumption that there's some situation that's going to spark. For example, the results of a court case earlier this year, and the internet is shut down on a preemptive basis, expecting there to be social strife. And what we're hearing from people is that the first step that they take is to shut the internet down because they're worried about rumors. That's from the administration. But when you talk to people on the ground, the one thing that we keep hearing from them is that the rumors spread person to person, and they're not able to validate any information because they don't have access to the internet. So I think my worry is that even though there was a rule that was passed in India earlier this year, and that seemed to have a stronger process for shutdowns where there were checks and balances in place, we've only seen the number of shutdowns increase despite these fresh checks and balances. And given that the next year is an election year with about 9 states going into elections, and we're seeing social strife as an outcome of hectic political activity leading up to elections, we're expecting shutdowns to increase next year, and that's very worrying.
Thank you very much for your comments. Can you maybe state your name and with what organization you are?
Sure. My name is Nikhil Pawa. I'm with the Internet Freedom Foundation in India.
Thank you. Thank you very much. Are there other questions in the room? Yes, over there. Please, in the back. You, yes.
Okay, good afternoon, everybody. Very interesting insights coming through from the panel. I'd just like to point out something else. Sorry, my name is Juliet, and I work with a collaboration for international ICT policy in East and Southern Africa, otherwise known as CIPESA. So just coming back to what has been discussed, we seem to be focusing quite a bit on the people who are already online. But some research that we've also done on internet shutdowns has shown us that people who are not on the net, who are not actively using the internet, are also affected by shutdowns. When we look particularly at cases where mobile money is affected, we recently produced a report on the economic impact of shutdowns, and previous reports may have not fully looked at that aspect of internet shutdowns, but we found that those who are offline are equally affected by internet disruptions. And when we look at it from the perspective of basic services or service payments being unable to be conducted, Peter mentioned the case of, what was it? Yes, the right to life. In many instances, basic services rely on mobile money payments, but we are at a point where we have no idea what impact some of the shutdowns have had on people who are very reliant on mobile money, what impact internet shutdowns have had on them. In cases in rural communities where a doctor will not service a patient if they do not have the capacity to make a payment, where a child will not be let into a classroom if the parent has not made that mobile money transaction. So I think we need to look at the conversation with a wider lens to include those who are not directly using the internet-based services, but to also consider those who rely on some of the related applications that also get affected by internet shutdowns. Thank you.
Thank you very much for those comments. Yes, over there, please.
Thank you. Thank you. First of all, thank you for all your presentations. My name is Patricia. I'm a fellow at the Internet Society Project at Yale Law School. I have a question for Dr. Tavares. Yes. When you present your definition about what an internet shutdown is, you said that it's justified under circumstances of national security and public protest. I would like to ask you more or less, if it's your definition, how did you elaborate it? I guess it came from the analysis of specific cases like maybe Brazil or Egypt, but this practice and the debate of shutting down the internet has been for a while already been discussed within well-consolidated democracies. And the reasons why they want to do it cover a lot more than the public protest. So I would like to ask you, how much do you know about those cases, and whether they will make you reconsider your definition of what an internet shutdown is?
Okay, thank you very much for your question. It was an introduction note. It's not really my definition. I try to resume what the main reports on the area said. For example, Internet Society has a fantastic report on that. They use that definition. Some companies like Google has a shutdown on the transparency report. They use it, some of their words to define what shutdown is. So it's a well accepted, I assume, definition by the broader multi-stakeholder internet community. So that's why I included on my statement just for as an introduction note to give you some food for thought. That's it.
Thank you very much for the question and the answer. Are there other comments or questions in the room? Yes, you would like to follow up on the initial question that you asked? Apologies.
My question is, my name is Giovanna, and I'm here with youth. My question is for everybody, but is a follow-up for her question actually. So okay, we have this. We have to investigate some crimes. That's something that we all agree here, I think. But I cannot see how this investigation, that is a punctual thing, can be a punishment for the whole society. However, we must investigate. So my question is, you mentioned our laws, the civil code and everything, but blocking everything or shutting down everything, we are violate the human rights conventions and Marco Civil and other laws. So by one way or another, we are violating laws and conventions. So my question is, what is the solution? Because shutting down is bad for everybody. Not shutting down is bad for these cases. And as I mentioned, there's how much would a mother would pay for remove these pictures from the sun. How much the mother who lost the baby would pay to have the baby. So I want to see something that would not prejudice one on the other, with some kind of the middle way. So that's my question. Thank you.
I think this is a very good question. I imagine that everybody on the panel has an answer on this. Who would like to shoot first? Volunteers?
How much time we don't have?
maybe a few quick comments because I imagine that everybody has. Peter, would you like to start?
Sure. Yeah, sure. That's a great question. I think, we could talk about having better societies where people don't commit crimes. I don't think that's going to be within the purview of this panel. I think if we're talking about law enforcement access to data, saying law enforcement are trying to stop and prevent crimes and also find those who are responsible. Law enforcement, because of the explosion of information in the internet age, have access to much more data and information than was ever previously possible. I think we center on these some few cases where things might be dark, where end-to-end encryption might protect the content of communications, but we really do maintain that there are many other tools at the disposal of law enforcement, tools and tricks and training and legal powers to access data, to surveil lawfully, I'd love to hear more from the panelists. Thanks.
Thank you very much. Yes, Monica, please.
Thank you. I would just like to highlight that Facebook has been working with law enforcement, providing metadata whenever it's requested. and content whenever it relates to child exploitation or emergency requests through a very fast process and through the international cooperation treaties when that content is required. But we have seen that metadata has a lot of value in criminal investigations, and it's usually used around the world as access to content as a last resource to that criminal investigations. This year alone, we've had a lot of successful stories of working with law enforcement in which the data that we were able to provide was very helpful to the successful outcome of that specific investigations. We are eager to continue to work in partnership with the law enforcement and with other key stakeholders in these issues.
Yes, please.
I'd like to say that that is the difference action between Facebook and WhatsApp. The problem with WhatsApp was that they didn't answer the judge minimums of answers to explain the kind of cryptation that they use and the difficult to give the answer about content for the judge, and sometimes they didn't answer the metadata too, and we have a lot of tools, as Peter said, to work in investigations, but sometimes to initiation of an investigation we need the metadata. It's essential, and we think that for answer of this problem, that we need the providers help us, walk with us and help us how to do best our work together, as Monica said that Facebook do.
Can I add something? Very quick, I think my answer for your question is cooperation. We talk a lot about international cooperation, but this cooperation must start inside our countries. We must cooperate. Multi-stakeholders is a super beautiful word, but we must use it. We must really go hand by hand, walking together. With this, we don't need to reach the panels. Thank you.
Thank you very much. And I think the essence of your question was what can concretely be done, because the current situation is unsatisfactory for all categories of stakeholders right now. Everybody is looking actively for solutions of how to make it work. How can we square the cross-border nature of the internet and national laws in a way that works? I take this opportunity to shamelessly say that the Internet and Jurisdiction Policy Network is a global multi-stakeholder policy network working on those issues. There's the second Global Internet and Jurisdiction Conference that we organize in Ottawa in partnership with the Government of Canada at the end of February. I will not elaborate anymore on the activities, but all those issues that are discussed here are actively addressed in this ongoing policy process, and we have a session on Thursday at 9 in this room, actually, if you're interested. We're entering the last 10 minutes, and I would like to stay on this beat of what can concretely be done. And remember, the purpose of this last segment was to look a bit ahead and say, in the next decade, what are the things that need to be solved? And I would maybe like to take the opportunity, starting with KS, to ask one last question to our panelists. If there's one thing that you think the multi-stakeholder community should address with regards to shutdowns, and maybe let's focus also on the issue of shutdowns and not only on the issue of blocking, which has been much more discussed than the issue of shutdowns, I think, by the international community so far. What is the main policy question that you would like to see addressed by the multi-stakeholder community, staying on the beat of what can be done concretely? Please.
I think there are two principles that multi-stakeholders can and should agree on. Number one, executive branch itself should not take down or shut down the internet, or even individual posting. Freedom of speech should not be perturbed on administrative initiative, because speech, by definition, is interactive. Should not be held responsible for its consequences, because the consequences of speech depend a lot on how it is received by the listeners, hearers, receivers of information. The second principle is the principle of proportionality. Some of the shutdown is issued by the independent judiciary of the country, but internet is not content. Internet is a place. Yes, some illegal posting may be up there on one day. Some other posting can come up on that same space. Now, the only way to shut down the internet or a part of the internet or website is to risk preventing posting of all those other lawful postings that could have come up in the same place. So, understanding that internet is space, not content, is something that we can try to agree on.
Thank you very much. Stephanie, what would be your policy question?
It's maybe not so much a policy question. I have an anecdote and then a follow-up from that. Because in Iraq, for example, the internet's been shut down to prevent cheating on exams for 11-year-olds. And that's happened multiple times. So I think the question on when, and I don't want to say this is that the internet should be shut down, but I think more research should be done on how and to what extent shutdowns are harmful to people, so that I think there's a better understanding of the harms that do occur when the internet is being shut down, and also more of like maybe principles and standards in terms of if you shut it down, how can you mitigate certain things if you want to do a targeted prevention of certain things, which I'm not sure I would, I don't know if, to like kind of mitigate some of the harms, not to say that you would agree with the principle in the first place, but yeah, maybe something like that.
So basically, if it's done, how should it be done?
Yeah, how can you mitigate like fallouts from what you're, because if you have a specific goal that you want to prevent with the shutdowns, and maybe an internet shutdown, but it's kind of like giving governments a toolbox to prevent freedom of speech, which is also not a good place to start. But if we're in a place where, and the problem is, like, I come from a background of Egypt where politics isn't really a place where you can go and you give policy advice and the government will listen to you. So it's like a place where you kind of like try to like, mitigate the harm. So yeah, that's my point.
Neda, what would be your policy question?
I'd like to summarize our speech.
Please put it on the microphone.
I'd like to summarize our speech. Said that law enforcement agents and providers, we must work together towards a more appropriate solution for the protection of the users and of the investigations.
Thank you very much. Susan, what is your policy question?
Well, I think the question that I need to ask is, what can the multi-stakeholder approach do to help solve this problem? So practically earlier I described the very practical need of conveying the technical ramifications of political decisions to decision makers. So supporting the very bright young minds that are entering this space with technical backgrounds to be able to convey those ramifications clearly and concisely. And I just wanted to mention the work of the Freedom Online Coalition very, very briefly, because we're working towards building solutions here. So that is a coalition of 30 like-minded countries, and the goal of the coalition is to serve as a coordinating body that advances cross-regional diplomacy and multi-stakeholder engagement to protect and promote human rights online. So while the Freedom Online Coalition is a group of governments. It does take a multi-stakeholder approach, and very practically, the coalition has just launched a call for expressions of interest to be part of the advisory network, and that is open until January 11th. So if you're from civil society, technical community, private sector, please take a look at that call, and so you could be part of developing a solution.
Thank you very much. Monica, what would be your policy question on those issues?
I'm going to take the liberty to go back to blockings, because that's the Brazilian reality. And the last point I'd like to make is there are currently several proposals on the table that would make the blocking of certain apps legal in Brazil. And so my policy question to that sense is, how can we as a multi-stakeholder group, what can we do to address that and make sure that doesn't happen?
Thank you very much. Carlos?
So I'll be super brief, just mentioning that even though it's true that internet shutdown is not a reality in Brazil, since we're asking more broadly policy questions, I would just suggest everyone in the room who'd like to see, since we're mentioning multi-stakeholderism all the time, of course, we all focus on CGI when we think about multi-stakeholderism in Brazil. There is one specific example of how multi-stakeholderism can act in practice, which is the fact of the closing of the port 25 TCP for sending out spam in Brazil, which is a really good example on how a multi-stakeholder group can get together to take a decision concerning the management of port 25 TCP. That was the case in Brazil. Brazil was one of the countries who used to send out most spams throughout the world. And by doing this, after a multi-stakeholder procedure, this situation was managed. So this is just one example, and CGI has prepared a document either in Portuguese and in English on that, so that would be maybe in Spanish. But that will be useful if you want to take a look on how multi-stakeholderism can act in practice, and just to give out this example. Thanks, Paul.
Thank you very much, Carlos.
Thank you.
Peter, please.
Yeah.
What would be your policy question? How to address those issues?
Thanks. Well, I would ask, well, I'd first ask if we believe that there is such a thing as a red line, as a floor below which we don't think it's acceptable for any actor in the internet sphere to fall below. And if there is that possibility, then how do we go about defining it? I think this statement from the Global Commission on the Stability of Cyberspace about not impacting the public core of the internet is an interesting starting point. And I would ask, then what every stakeholder group can do. And personally, with civil society, we've organized in the hashtag Keep It On coalition. Certainly invite more to join. It's the most productive listserv I've ever seen in civil society, for one thing. And I think the telecode.
I don't know where either, so I'll ask Olga where she Look at this. Not that I haven't snuck some water in there. Alright, so I guess I'll wait.
Yes.
Hey. Good to see you. I think Geneva's 3, but 2 is good.
It's 2 or 3?
Geneva's 3.
Good afternoon, everyone. We will start in a few minutes. Welcome to our session, and stay with us.
Oh, good to see you again. Yes. Asian Bell first. I am.
Congratulations on the
Yeah, this is, yeah. Okay. This is for men, yeah, exactly. On Thursday,
Because I can do it from here.
Okay, I'll try to make that. Okay, thank you. I write you with my
Congratulations. Excellent. Thank you again.
Thank you. Congratulations on your work.
Ça fait, tu sais, ça fait juge, troisième chambre criminelle du TGI, de je sais pas quoi. Tu connais